Welcome to the deep dive. We take complex stuff, pull it apart, and give you what you really need to know. And today, well, it's a pretty specific mission. We're going deep, really deep, into the legal side of BitTorrent copyright issues, specifically lawsuits from one company. Strike 3 Holdings, LLC. You might see them called S3H.
Right. And what we're doing here is taking insights directly from, legal experts, the ones who actually defend people in these exact cases. Think of this as a roadmap. We're cutting through the noise you see on forums online and giving you a clear picture of the actual legal steps and, importantly, your options.
Okay, so let's set the scene. Who is Strike 3 Holdings?
Well, as 3H, they're an adult film company. They own brands you might recognize like
Yeah.
Vixen, Blacked, Tushy, Milfly, those kinds of things. And their lawsuits. They all start the same way. They track an IP address they claim downloaded their content illegally using BitTorrent.
An IP address, so not necessarily a specific person, just a connection.
Exactly. It's tied to an internet account. Initially, the person who owns that account is just listed as John Doe in the lawsuit. The whole case starts with linking that IP address, those numbers, to a download. Not proving who did it, just that it happened on that network.
Got it. So let's talk about how this usually plays out. You mentioned a cadence, a pattern.
Yeah, there's a definite pattern, and timing is absolutely critical. It really breaks down into a few steps. Step 1. S3H files the lawsuit against John Doe in federal court.
Okay.
Then, almost immediately, they ask the judge for permission, it's called leave of court, to send a subpoena. But crucially, the subpoena goes to the internet service provider, the ISP.
Yeah.
Your Comcast, your Verizon, whoever.
Ah, okay. So the subpoena isn't coming to the person, the John Doe, directly at first.
Not at this stage, no.
Yeah.
That's a really common misunderstanding you see online. The very first thing the user typically receives is actually a notification from their ISP.
A letter. Or an email.
Usually a letter, sometimes an email. It basically says, hey, we got this subpoena asking for your name and address linked to this IP address on this date. And this is the critical moment, because when you get that notice, you are still anonymous.
Anonymous to Strike 3. And in the court records.
Exactly. You're still just John Doe to them and to the public. This kicks off a really important window. It's usually 30 days, sometimes less. And this is when you have the most leverage, the most options.
Okay, that 30-day clock is ticking. What happens if someone just ignores that ISP notice, hopes it goes away?
Well, it won't go away. If you do nothing, the ISP is legally obligated to comply with the subpoena. They will release your name and address to Strike 3 Holdings lawyers.
Right. And once S3H has the name, then what?
Then they move to the next steps.
Yeah.
Step 2 and 3 kind of blend together. They have your identity. Now they have a choice. They can dismiss the case. Often they do this without prejudice.
Okay, let's unpack that legal term. Without prejudice means they can drop it now, but they reserve the right to sue you again later. It's not truly over.
Precisely, yeah. It means the legal issue isn't permanently resolved. They could refile if they wanted to. The other path is they amend the lawsuit. They swap out John Doe for your actual name.
Ah. So now it's public record with your name attached?
Potentially, yes. And then they'd serve you with a formal summons. That means you are officially, personally being sued. Which path they take, dismiss or amend, often seems like a bit of a gamble, based on how S3H perceives the situation. Some sources call it a test of your tolerance for risk.
That sounds incredibly stressful.
Oh.
Okay, before we get into the defense options, are there any big mistakes people make right at the start? Things that could really hurt them down the line?
Yes, definitely. 2 huge ones based on what the legal experts advise. First, don't sign anything S3H sends you directly, especially not some kind of confidentiality agreement, without talking to a lawyer first.
Okay, don't sign. What's the second one?
This is critical if you're even thinking about fighting it. Do not delete anything. Don't delete files, don't wipe drives, don't clear browser history related to this.
Why not? Isn't that just cleaning up?
Because in court, it can be seen as spoliation of evidence, destroying evidence. That can be interpreted as an admission of guilt, or at least make you look very guilty, and it can lead to really severe penalties if the case goes forward and you lose. Preserve everything.
Wow. Okay, preserve evidence, don't sign anything. Got it. So someone gets the notice, they understand they can't ignore it, they need a strategy. What are the main paths forward? Our sources seem to boil it down to 3 main options.
That's right. It really depends on your goals, your stomach for risk, and your specific situation. Let's start with option 1, anonymous settlement.
Anonymous, meaning you settle it before your name ever becomes public.
Exactly. This is for people whose top priority is privacy, keeping their name out of the court records, resolving it quickly and discreetly. But, and this is key, You have to pursue this during that initial anonymity window, before the ISP hands over your info, before you get a summons.
Right, but settling, it feels like admitting you did something wrong, even if maybe you didn't, or someone else on your network did. How does that work?
That's the trade-off, really. You're not necessarily admitting guilt in a legal sense. You're paying to make the problem go away and guarantee anonymity. S3H has the leverage of potential public exposure, plus the huge cost of fighting a federal lawsuit. Settling buys you out of both those threats.
Makes sense. What kind of money are we talking about? I hear the initial demands can be huge.
Oh, they can be staggering. The
Mm.
lawsuits often list, say, 20 movies, sometimes over 200. And S3H's initial ask is often around $750 per movie. That can push demands towards, $50,000.
$50,000.
Yeah,
Seriously.
but that's the starting point, the opening demand. This is where having specialized legal help really makes a difference. Experienced lawyers who do this every day often negotiate settlements way, way down.
How far down?
It varies a lot, of course, but averages might fall between, say, under $100 per movie up to maybe $500 per movie. And in cases where someone can show real financial hardship, settlements have apparently gone as low as $250 total, just a flat fee to close it.
That's a massive difference. So, besides the money, what's the big advantage of settling through a lawyer versus trying to DIY?
Peace of mind, really. It's about getting a complete release of claims. If you settle yourself, you might only settle for the specific movies listed in that lawsuit. But what if they find more later? A proper settlement negotiated by counsel covers all alleged downloads before the settlement date. Everything. It builds a legal firewall. That's the real value.
Okay, total closure. Got it. Let's move to option 2. Fighting the case in court. This sounds like the route for someone who feels strongly they're innocent or just objects to the whole thing on principle. High risk, maybe high reward.
It can be, but first things first. This is a civil lawsuit, not criminal. So no public defender. You absolutely need your own lawyer, and ideally one experienced in these specific types of cases.
And what does fighting it actually involve?
It involves litigation. That means discovery, exchanging evidence, documents. You almost certainly have to give a deposition.
A deposition, that's like being questioned under oath.
Yes, exactly. A formal interview, recorded under oath by S3H's lawyers. The defense strategy isn't usually about proving you didn't do it. It's about attacking S3H's evidence, finding fatal flaws.
Flaws like what?
Well, like we said, they only have an IP address. Can they definitively link that IP address to you specifically downloading the file at that exact moment? Maybe the Wi-Fi was unsecured. Maybe someone else lived there or used the network. Maybe their tracking method itself is unreliable. You challenge the technical case.
But what if you decide to fight, but then you get served with that summons and you ignore it?
Oh, that's the worst case scenario if you intend to fight. Ignoring a summons basically guarantees a default judgment. That means you automatically lose. The court will likely award S3H statutory damages, which can be much higher than a settlement, plus their legal fees. And once you're served, you're leveraged to negotiate a settlement later. It plummets. The price goes way up.
Okay. So don't ignore the summons. What's the third option? Filing a motion to quash.
Right. This is more of a technical legal strategy. You're not arguing guilt or innocence yet. You're arguing that the lawsuit itself, or the attempt to get your information, is legally flawed.
Oh, so?
Often it's about jurisdiction. S3H likes to file suits in certain places, maybe D.C. or California where they are based. If you live in, say, Texas and have no connection to D.C., your lawyer might argue that the D.C. court has no power, no jurisdiction over you. Forcing S3H to refile in your home state costs them time and money. It adds friction.
And I think our sources mentioned something about Florida and pure bill of discovery laws. What was that about?
Yeah, that's a specific state law thing. Some states, like Florida, have rules basically saying you can't use a lawsuit just to fish for information, which is arguably what S3H is doing initially. So in some Florida state court cases, not federal motions to quash based on those rules have actually succeeded in getting the subpoenas thrown out. It's not common nationwide, but it shows a possible technical angle.
It all sounds incredibly technical, which brings up a point. Why can't someone just use their regular family lawyer?
Look, it's like having a weird, rare medical condition, right?
Yeah.
You wouldn't go to your regular family doctor. You'd find the top specialist who deals with only that condition. This is a niche area of federal law. Copyright litigation, BitTorrent evidence, ISP subpoenas. It's very specific.
So general practice lawyers might not know the nuances?
They likely won't know the specific defenses that work, the current settlement ranges, the judges who handle these cases, S3H's specific tactics. You need someone who lives and breathes this stuff. And because copyright is federal law, a specialist lawyer licensed in federal court can often represent you no matter where you live in the U.S. The firms we looked at handle cases nationwide, thousands of them against S3H and others.
Which really makes you question the advice you see on random internet forums, right?
Oh, absolutely.
Yeah.
Relying on forum advice is playing with fire. There's this persistent myth, for example, that contacting S3H to settle early puts a target on your back.
Mm-hmm.
That's just wrong. By the time you get the ISP notice, the target is already there. The question is how you manage it. Settling early, anonymously, leverages that brief period where you still have some control. Waiting until you're named just weakens your position and drives up the cost.
It really seems like the best strategy is super personalized.
It has to be. How many movies are alleged? From 20 to maybe 240? That's a huge range. What's the client's real financial situation? How much risk can they tolerate? And then there were special situations. Maybe it was a minor child who did it or a house guest. Those facts can drastically change the negotiations, sometimes leading to a very quick, low-cost resolution or even dismissal.
So, pulling it all together, what's the absolute core takeaway here?
The moment you get that notice from your ISP, that initial letter or email, that is your moment of maximum leverage. It's the best time to preserve your anonymity, explore your options, and potentially negotiate the most favorable outcome. Waiting almost always makes things more complicated, more public, and more expensive.
Act decisively during that anonymity window.
Got it.
All right, as we wrap up this deep dive, here's something to chew on, a final thought prompted by our sources. Strike 3 Holdings itself has apparently stated in court filings that the money they actually recover from these thousands of lawsuits is only a tiny fraction of their overall revenue. So if the main motivation isn't purely the cash collected from settlements and judgments, what deeper purpose might this constant high-volume litigation serve for intellectual property holders like S3H? And what does it mean for privacy and anonymity online?